Thank you very much. Thank you all for coming. I'm here to introduce Judge Denny Chin. But before I do that, I want to acknowledge David Cortright. I just asked him before I came here if about 50 years ago, did he ever think that he would stand here in front of us where we all are experiencing this reenactment of this trial, and obviously he could not have imagined it in his wildest dreams. So it's really exciting to be here in front of you all and to acknowledge David, not only in his activism that has started as a soldier all the way to the present, but also his scholarship work and his leadership at the Kroc Institute. It's really thrilling for us as a community at Kroc to be here and to witness this reenactment. So, a few words about Judge Denny Chin. He is a United States Circuit Judge for the United States Court of Appeals for the Second Circuit. He had previously served as the United States District Judge for the Southern District of New York. He is the first Asian American judge appointed to federal district east of the Ninth Circuit, and the first Asian American judge appointed to any federal circuit. In the district court, Judge Chin presided over a number of important matters, including cases involving Megan's Law, the Million Youth March, Al Franken's use of the phrase fair and balanced in the title of a book, The Naked Cowboy, and the Google Books Project. He also presided over two criminal trials arising out of the United Nations Oil for Food program, as well as the trial of an Afghan warlord charged with conspiring to import heroin, and the guilty plea and sentencing of financier Bernie Madoff. I think for some of us, we can resonate with some of these cases that the judge presided over. Judge Chin has received numerous awards and honors, including the Woodrow Wilson Award from Princeton University, the Spirit of Excellence Award from the American Bar Association, the Lifetime Achievement Award from the Judicial Friends, the Italy Award for Leading Women and Children to Safety from Sanctuary for Families, and the Tailblazer Award from the National Asian Pacific American Bar Association. He has received honorary degrees, honorary doctorates from Fordham University and CUNY Law School, and has given commencement addresses at many universities and law schools. Judge Chin, in addition to all of these activities, loves teaching. He has taught legal writing at Fordham Law School since 1986, and this spring he teaches at the Harvard Law School. Judge Chin and his wife, Kathy Iraga Chin, have been the principal authors of a number of scripts of reenactment, historic cases, including This Land is Our Land, Oyama versus California, Constance Baker Motley, James Meredith and the University of Mississippi, Justice Denied, Ward's Cove versus Antonio, the Harp Mountain Draft Registers, Conscience, Loyalty and the Constitution, and 22 Luke Chinese Women, China Lang versus Freeman. These programs have all been presented all around the country, including at numerous law schools and universities. This latter activity, obviously, is what brought Judge Chin to Notre Dame, to the Kroc Institute, and to the law school. So please join me in welcoming Judge Chin to the school.
Good afternoon. I'm delighted to be here at South Bend, my first visit to Notre Dame. I was asked to say a few words about the program that you will see in just a moment. I had a nice breakfast with some law students. Some of them are in the audience this morning. And I wish I had a little more time to spend here. I'm heading back early tomorrow morning. So I've been doing these reenactments of historic cases for 15 years or so, and my wife and I have been doing them with the Asian American Bar Association of New York for about 12 years. I started 15 years ago with the Inn of Court in New York, so those two groups, and then we've done some additional ones on the side. And these are great teaching tools. You're going to see it performed today, but the researching and writing and putting together the scripts is really a fun and educational process. And we have a team of lawyers and judges in New York who work on these. The very first one that I did was Lizzie Borden, the axe murderer. And you can find the transcript of the trial in Massachusetts back, a long time ago. And from that first time, I was just taken with this process. We try to find a case where there is a compelling story. We try to talk about the people involved. We try to find cases with trial transcripts, so we rely heavily on the actual words. We also try to find cases that raise issues that are still important today. So a few years ago, to celebrate its 125th anniversary, the Second Circuit asked Kathy and I to work on a reenactment to celebrate the Second Circuit. And we worked with the staff attorney's office, a group of young lawyers on the court, and we came up with a program that was really 3 reenactments. It was called 2 Wars and a Book. The book was the Ulysses Obscenity case. Then there was a World War II criminal case about a munitions plant. And the third case was this interesting First Amendment case that we found called Cortright versus Resor. And so it was 3 reenactments into one program, and then at some point, my in-court team decided to take the last part, the Cortright case, and build it out into a full program. And so we were going to do that a couple of years ago, and I was saying, well, maybe I can find Mr. Cortright. And Professor Cortright was actually quite easy to find. Once I Googled him, this was 40 years after the case, so I wasn't sure. And then I reached out to him, and he was kind enough to come to New York for the first time when we did this. And he played himself at the end. And then we did it again in Hawaii, and we had to twist his arm for to make it down. But they both came out to Hawaii, where we did it in a somewhat different setting. It wasn't a courtroom, but it was Hawaii. And so when David asked me to come to Notre Dame to participate, of course I was delighted to do so. I'm glad to be here. When we're done, we'll have a little time for Q&A. Before I forget, a couple of people have been asking if you're interested in reading more about our scripts. We have 2 websites, and you can even make a request to get a script. And then the idea is that people can take these scripts, perform them in their own communities, perform them at schools, bar associations, etc. The first one is a Second Circuit website. If you Google Second Circuit Justice for All, this is a civic engagement project that our court is involved in, and there will be reenactment pages. In addition, if you Google Albany Asian American Bar Association of New York trial reenactments, you'll find a website where we have 10 different programs listed, along with some photographs and excerpts. For each of our programs, we have a great set of slides. We find these historic slides that help tell the story. And without further ado, we will turn the proceedings over to narrators 1 and 2.
On November 9, 1969, a full-page ad appeared in the New York Times. It was an anti-war petition signed by more than 1,300 active duty service members, including 39 members of the 26th Army Band stationed at Fort Wadsworth on Staten Island. The petition demanded an end to the war and called for immediate withdrawal of all American troops from Vietnam.
David Cortright, a member of the 26th Army Band, signed the petition and circulated it to the other band members. For this and other activities, Cortright was removed from the band and transferred to Fort Bliss, Texas. He sued, alleging a violation of his rights under the First Amendment.
What happens when soldiers question morality of war? Do soldiers have First Amendment rights? What can the military do to respond to protest by those who are the closest to war? This afternoon, we look at the legal issues presented when soldiers speak against war by examining Cortright versus Resor, a case decided in 1971 against the backdrop of the Vietnam War. We consider both the trial proceedings in the Eastern District of New York and the appellate proceedings in the Second Circuit, drawing from trial transcripts, the appellate briefs, and other contemporaneous writings.
Judge Joseph M. McLaughlin served as a judge in both courts. Upon his elevation to the circuit in 1990, he made this observation about the difference between the trial court and the appellate court.
As I now turn my back on the great human drama of the trial court and enter the scholastic life of an appellate court, I have these nostalgic feelings. You all know the old saw: trial judges finish the fight and go on to the next battle. Appellate judges come down from the observation tower, prowl the quiet battlefield, and shoot the survivors. The big difference, of course, is that the trial judge works alone. And within his courtroom, he is sovereign. The appellate judge, however, is just one member of a panel and is charged with the duty of working toward a consensus where possible.
Ladies and gentlemen, we present When Soldiers Speak, Cortright versus Resor.
The Vietnam War was one of the most controversial armed conflicts in history. It lasted from 1954 until 1975 and had its roots in the 19th century when France established a colony in Vietnam. During World War II, Japan invaded Vietnam, and when the war ended, France tried to reassert authority over Vietnam. Ho Chi Minh and his Communist Viet Minh Party resisted, with support from China and the Soviet Union. He declared an independent North Vietnam and fought to unify Vietnam.
Against the backdrop of the Cold War and as part of its mission to prevent the threat of communism, the United States supported France and South Vietnam, first with military advisors in the 1950s and later with troops. The United States reinstituted the draft in 1962 to meet the rising need for troops. By 1969, at the peak of U.S. involvement in the war, more than 500,000 U.S. soldiers were in Vietnam.
As the U.S. involvement increased, so did dissension within the United States. Anti-war protests and counter-protests broke out. In April 1965, some 15,000 students marched on Washington to protest the war. And in October that year, some 25,000 people converged on the city to support the war. In 1967, anti-war protests swelled, with 70,000 people marching in New York City and 100,000 in Washington, D.C. Protest groups organized draft card burnings, and some protests turned violent.
Many of the members of the military also objected to the Vietnam War. This was not a new phenomenon. As one historian has written,
soldiers in revolt go far back in our past to the days of the Revolutionary War and the Civil War. But the anti-war protests of the Vietnam era were certainly the most massive, the most successful in the nation's history. The Vietnam War was the most unpopular war in the nation's history. This unpopularity led to difficulties in recruitment, an increase in conscientious objectors, an extraordinary number of GIs going AWOL, acts of sabotage and obstruction, and not only the quiet avoidance of combat, but outright mutinies in the field.
In 1968, after graduating from Notre Dame, where he was the drum major of the band of the Fighting Irish, David Cortright received a notice to report for induction into the U.S. Army. He enlisted for 3 years under an agreement that he would be assigned for at least 1 year to the 26th Army Band. While in the Army, he became a peace activist and posed in uniform holding a dove for photographer Richard Avedon. As Cortright explained some years later,
I served in the U.S. Army during Vietnam, an experience that made me realize fully the horror of war. Uncle Sam, turned me into a peace activist. To avoid being sent into the infantry, I signed up for the Army Band. Yes, I defended my country by playing a baritone horn and trumpet. Before I entered the Army, I had not really thought about war. As I went through basic training, however, questions began to arise. The explanations our commanders gave us for why we were in Vietnam did not ring true. The returning war veterans told me harrowing tales of what they had experienced. Doubts began to swirl. Questions turned to shock and outrage as I realized the war was unjust and immoral. One day I saw a magazine story about soldiers in Fort Sill, Oklahoma, speaking out against the war and forming a servicemen's union. That was it. I could oppose the war even as an active duty soldier. I became part of the GI anti-war resistance.
On July 4th, 1970, the band led a parade on Staten Island. 5 women, Cortright's fiancé, and the wives of 4 other band members marched behind the parade, carrying signs that read,
"Military wives for peace! Nixon war! Kill poverty, not people! 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 Kill poverty, not people!
Cortright married his fiancée a few months later. They later recalled.
Dave mentioned he had heard a rumor that some of the wives are planning to demonstrate against the war. I asked him how could I get in touch with them so I could find out more about it.
I suggested she call one of the wives.
I did. She said a few of the wives were going to hold picket signs at the parade. I decided to join them.
Some of the spectators were quite upset that they were carrying peace signs.
I was hit in the chest with a can of grape soda. One of the wives was struck by a member of the local veterans unit.
The police had to get involved and escorted them away for their own safety.
We were very frightened.
After the parade, all hell broke loose. The Army changed our schedule to include work details, longer hours, extra training, stricter enforcement of haircut regulations, and the elimination of teaching private band lessons. Finally, the Army transferred the 8 ringleaders to the 4 quarters of the world, including Vietnam. I was transferred to Texas, Fort Bliss to be precise.
On July 22nd, 1970, before reporting to Fort Bliss, Cortright brought a complaint against his commanding officers under Article 138 of the Uniform Code of Military Justice. The next day, he filed a civil suit, a class action, in the Eastern District of New York. The case was stayed pending the military proceeding, which concluded with the finding that Cortright's transfer was essential to the continued effective performance of the community relations mission of the 26th Army Band, and that the transfer was not punitive in nature.
The civil suit was assigned to Judge Jack Winstein, who conducted a 2-day non-jury trial in December 1970. Cortright was represented by Frederick Cohn and Martin Stolar. The government was represented by Assistant United States Attorney Lloyd Baker and Captain John Lenga of the U.S. Army. Cortright had already been sent to Texas, but he came back for the hearing. He was the first witness. Cohn conducted the direct examination, and AUSA Baker cross-examined.
Mr. Cohn, you may proceed.
Thank you, Your Honor. Specialist Cortright, I call your attention to November of 1969 and ask you if you participated in the circulation of a petition against the war in Vietnam.
Yes, sir.
Where did that petition appear?
In the New York Times.
And among whom did you circulate the petition?
Members of the 26th Army Band and other soldiers I knew at Fort Wadsworth.
Did you permit that activity to interfere in any way with your duties as a soldier?
No.
Now, in the spring of 1970, were you involved in another petition?
Yes.
Would you explain the circumstances surrounding that petition?
The same group that published the first petition, the Student Mobilization Committee, decided to sponsor another ad in the New York Times and mailed copies of the petition to GIs who had signed the first petition, many of them at Fort Wadsworth. I had an apartment near the base, and members of the band and I met there. We discussed the petition. Many of us signed it. By April 1970, we had approximately 40 signatures, and we mailed them to the group.
What happened to the petition?
In April 1970, 2 sergeants came to me. They said they were afraid about the band signing the petition. They said if the petition were published, the base command would look very unfavorably upon us, and that the Army would punish us. They said we had no right to jeopardize the entire unit. I told them that we had done nothing wrong. The petition was legal. The sergeants insisted that the whole band should be made aware. A meeting of the band was called. I stated my position. They stated theirs.
Did you have any additional discussions about that second petition after that meeting?
Yes. Sergeant Flores called me into his office and asked, "What's with the petition?" He called it unwise, said that the Fort Hamilton command was watching, and that we should be careful. Flores said that although we had rights, the Army also had rights, and that we should withdraw our signatures. Over the next 2 days, I took an informal poll of the band, whether they wanted their names on the petition. 27 were against, 23 for. We abided by the majority and withdrew the petition.
Now I call your attention to July 4th of this year, 1970, and ask if you recall a parade in which the band participated on Staten Island.
Yes.
Did there come a time when you became aware that something unusual was going to happen in connection with that parade?
Yes. A day or 2 before the parade, one of the members of the band told me his wife and other wives intended to have a small demonstration against the war in Vietnam right at the parade. I wasn't married at the time, so I was not involved in it. The day before the parade, though, he told me that I should tell my fiancée that she should get involved in the parade. So Friday night, I told her that she might call one of the wives. She did, and that was the last I heard of it.
Well, were you aware of what the women were intending to do?
They were going to carry signs, stand alongside the parade route, and demonstrate against the war in Vietnam.
Did you offer any advice on how this was to be done?
No.
Did you advise them against it?
No, I felt against it, but I didn't offer any advice.
Did you observe anything unusual during the parade?
The band lined up at the beginning of the parade. A few minutes before the parade was to begin, I saw the wives and my fiancée walking down the road with their peace signs.
After you saw them, what happened?
I was standing at the front of the band. They walked behind the band, and I didn't see them again until the end of the parade.
On July 8th, you were called to a special formation by Sergeant Flores.
Yes.
What transpired there?
Band members were very nervous. Sergeant Flores came in very angry. He said from then on things would be different. Regulations would be strictly enforced. Sergeant Flores explained that the changes were not just the result of the parade, but also of the petitions. He advised us not to fight the changes, and that if we did nothing wrong, the changes might go away. And he said he had the power to make additional changes.
What happened next?
We decided, the GIs and myself, that we should initiate an Article 138 complaint against the Fort Hamilton Command.
Did you, in fact, file such a complaint?
Yes.
What, if any, result came from that?
I received a letter in October 1970 telling me that the complaint had been investigated and that there were no grounds for my complaint.
Did there come a time when you received orders transferring you out of Fort Hamilton?
Yes. On 17 July, I received orders that I was to report to Fort Bliss on the 24th of July. My will proceed date was the very date I received the order, 17 July.
I call your attention to July 13th, 1970, shortly before you got your orders. Was the band addressed by Colonel Thomas Merrick?
Yes. Colonel Merrick spoke to the members of the band. He told us that there were no grounds for our complaints, that the changes were something that had been planned by the Fort Hamilton Command, and that it was just normal Army duty. I raised my hand and I asked whether or not this was the official response to our complaint. Colonel Merrick asked that I state my name and spell it. Then he said, yes, this was the official response. 4 days later, I received my orders transferring me to Fort Bliss.
No further questions, Your Honor.
Mr. Baker, cross-examination.
Yes, Your Honor. Mr. Cortright, Is it fair to say that you were the moving and motivating force behind the circulation of both petitions to the band?
Yes,
You spoke out as a spokesman for the band, as an anti-war group?
I spoke out against the war often. All the members of the band had the same sentiment I did.
With respect to the incident on July 4th on Staten Island, do you know who made the signs?
I don't know. I think the girls got together to make the signs.
Did you help make the signs?
No,
Nobody ever ordered you to withdraw the petitions, either one of them?
I was strongly advised to do so by Surgeon Flores.
Nobody ordered you?
No, there were no direct orders.
No further questions.
Mr. Cortright, you may step down.
Conan Stoller called several other members of the 26th Army Band. Here are band members Roger Brooks and Vern Wyndham.
I was teaching public school when I was drafted in 1969. I had views against the war. They tried to change those views in basic training, glorifying war, trying to instill killing into us. I signed the first petition and the second. We never showed our views during duty, never when the band played. But after the second petition, we were told there would be a great deal of harassment and punishment coming down. I decided it was better to remove my name from the second petition. The punishment still came down, even though I took my name off.
I graduated from the Eastman School of Music in 1968. After I received my induction notice that summer, I enlisted in the 26th. In November 1969, I signed the first petition. I was opposed to the American presence in Southeast Asia. I received the second petition and signed that too. Then Sergeant Flores told the band that he would not have this in his unit, that he didn't have these problems in Vietnam, and that over there, he had ways to solve them. I withdrew my signature. It was a hard decision. I wanted to say more against the war, but I did not want anyone to suffer retribution. We were still retaliated against. Schedules, duties, everything changed. We stopped functioning as a band.
After Cortright rested, the government called its witnesses. The Army's principal witness was General Richard Cicolello, Chief of Staff of the 1st U.S. Army. He was examined on direct by Captain John Langa of the Army.
Captain Linga, you may proceed.
General, in July of 1970, did you have occasion to receive reports regarding the 26th Army Band?
Yes, when I got my first briefing, the 26th Army Band came up. I got the impression that they had some elements who were causing problems for the commander at Fort Hamilton. Then in July, we had reports of the 26th Army Band marching in parade with some of the girlfriends and wives falling into formation with placards opposing the war.
Did you have occasion to learn about Specialist David Cortright?
He came to my attention as being the more vocal one, the one who apparently was a troublemaker.
Did you form any conclusions about the effect of Specialist Cortright's activities on the band?
Yes, it was my judgment that what he was doing was weakening its general morale, its discipline and effectiveness.
Did you take any action regarding Specialist Cortright?
I asked the staff to look into it. They determined that the band had not been drawn down to its authorized strength. I asked if Cortright was eligible for transfer, and they said he was. I told them to move him.
What did you intend to accomplish by transferring Specialist Cortright?
We intended to strengthen the band and make it a better military unit, a unit that would accomplish its mission.
Did you have any intention to punish Cortright?
No. If we did, we would have tried it. We just transferred him.
Did you regard his transfer as punishment?
It was not punishment.
Generally, how do you feel about dissent in the Army?
We recognize very clearly in the Army that any soldier, just like any citizen, has the right of free expression, and we give it to them. In the Army, however, we also must develop and train effective military units that will do what this nation expects, We have to impose reasonable restraints on dissension, and we do so only when we feel that dissent weakens the effectiveness of the military unit.
Cohen cross-examined.
General, does the Army discourage dissent?
The Army doesn't go about discouraging dissent. The Army doesn't discourage legitimate dissent. I took the action I did not because of Cortright's ideas on dissent, but because of his activities in the band.
What were his activities in the band?
He was fostering a general attitude of dissension, a general attitude of unresponsiveness to good order and discipline.
Did you feel it was necessary to transfer others out of the band to maintain morale?
Well, the principal one, of course, was Cortright. And then we left the balance up to the staff to see who was surplus.
As to the parade, what evidence do you have that band members invited the women to participate?
That was an assumption on our part. In the military, we hold the husbands somewhat accountable for the actions of their wives.
I have no further questions.
The government also called Thomas Merritt, the deputy commander of the Fort Hamilton Command, which included Fort Resor. He was examined by Captain Langa.
Colonel, in November 1969, was the band called to your attention?
Shortly after my arrival, I learned the names of some of the band members had appeared in an advertisement in the New York Times, along with many other names against the war in Vietnam.
Did you take any action against those individuals?
No, I didn't. There was really no basis for doing so.
Directing your attention to July 1970, did you have occasion to meet with the band?
Yes, I did.
What were the circumstances which resulted in you meeting with the band?
General Higgins had received a letter with Specialist Cortright's return address on it. It was a mass complaint from several members of the band stating their commanding officer had imposed certain restrictions or extra duties, and they were taking exception to this. The following Monday morning, General Higgins discussed the letter with me. We decided that the appropriate thing to do would be to have a discussion with the band and see if we could find out what the problems were.
At this meeting, what did you tell the men?
Well, specifically, there was no way, this in no way was intended to be punitive or in any way restrictive of the alleged dissent they had participated in. I went over each item they had complained about, pointing out that all these things that the band was expected to do, there were no abnormal duties.
In May or June 1970, did you receive any reports about Specialist David Cortright?
Yes. In May, we received word in the command that a petition similar to the one that had appeared the previous November was circulating amongst the band members, and that there was talk in July that signers of this petition would be included in an advertisement to be placed in the New York Times, similar to what had been in the previous November.
Based on those reports, what conclusions did you arrive at regarding Specialist Cortright's activities and their impact on the band as a military unit?
We recognize that as far as petitions are concerned, there is nothing illegal about the individual voicing his dissent, whether he is in the service or out of the service. But as far as Cortright was concerned, he was the man who was heading it up, and Flores did ask Cortright to consider withdrawing the petition. My feeling was that the purpose of the band is to represent the Army in New York, and in place primarily before military orders like the veterans of foreign wars, and really when it was associated with the band as a military unit, it's not what we would be looking for as an Army representation in New York.
Did you ever report your beliefs regarding Cortright's activities to a higher headquarters?
I did. As I recall, on the 4th of July on Staten Island, there was a demonstration. The band was playing, and there was, on the following Monday morning, a piece in the paper about demonstrations of Army wives alongside with the band, and a rather irate crowd, and they had signs against the war.
What was the nature of the reports that you made to headquarters?
After this 4th of July incident, I did discuss with one of the staff officers the fact that it had occurred. In July, 4 of the women were identified as wives of band members, and 1 woman was identified as a fiancée of Specialist Cortright. It was becoming obvious that Cortright was doing more than just expressing his own individual dissent. Cortright was the focal point of all this. The right of dissent is anybody's own business, but when it's taking place on post during duty hours with the band, this is going beyond the normal expectations of an individual in such a unit.
Did you have anything to do with the transfer of Cortright?
Well, after the letter went to General Higgins, around the 11th of July, I did discuss again with the 1st Army staff the situation. The question did come up, do you want to transfer him or should he be transferred? I advised that if he could be, I thought it would be appropriate.
Colonel Merrick was cross-examined by Mr. Cohn.
When you heard about this second petition coming out, you felt that publication of that petition would reflect badly on the band. Is that correct?
I felt that it would not do any credit to the Army or the band.
Did you feel it would interfere with the public relations mission of the band?
I felt it very well could.
When was the first time you talked to the First Army about Cortright?
As I recall, it was sometime after the 4th of July, around the 5th or 6th. I brought to the attention what happened, the fact that the article did appear in the papers, the Staten Island papers, on Sunday or Monday, I believe it was, and what it said.
Didn't you discuss that with General Higgins first?
Oh, yes, I did.
In fact, didn't General Higgins tell you to call the First Army and discuss the Cortright situation with them?
He agreed that I should, yes.
Did you talk to the First Army about getting rid of Cortright?
At that time, no, I did not. After General Higgins had received the letter of what was described previously as a mass complaint on the 11th, I discussed it again.
Did the band fail to perform its commitments in any way because of this dissent?
Not to my knowledge, no.
Did they disobey orders because of the dissent?
No, they never did disobey orders to the best of my knowledge.
Did the general stop getting letters commending the band because of his dissent?
We have had many comments from citizens regarding the band, and part of they play in the particular subject we are discussing, but they still received quite a few commendations. They still do. They were a fine playing band, and still are.
To your knowledge, has Specialist Cortright committed any breach of the Code of Military Justice?
To my knowledge, he has not.
No further questions.
The lawyer summed up with Assistant United States Attorney Baker arguing for the Army and Cohen for the band members.
Colonel Clyde testified that the overseas assignments were made in response to valid requisitions. These requests were initiated long before the incident in question happened. If an overseas command makes a request for more trombone players, that is for the Pentagon to decide, not for any court to say they can't have those trombone players. The general made a good faith assessment of the situation and determined there was indeed a military necessity to transfer Cortright, given his activities and the unfavorable publicity that had started. This is not something which is reviewable by a court. There's no case which says any court has the jurisdiction to review and set aside the Army's assignments of its soldiers where it wants, anywhere in the world. There's absolutely no precedent for a court to enjoin the Army from assigning a man. Military necessity is for the Army to determine. Even if it were otherwise, is the court going to take the position that the requisitions cannot be filled? If these 6 men don't go, what about the 6 men who have to go in their place? Additionally, Mr. Cohn seems to be basing his case on the incorrect premise in the first place that constitutional rights apply. This circuit has held that constitutional rights do not apply to soldiers in the Army, to servicemen. The whole thing is based on an incorrect premise. Now, the Army has said that servicemen have a right to their own opinions and to express those opinions. The Cortright activities went far beyond that. By his own testimony, he was a spokesman, an organizer. He circulated these petitions around the post, and in doing so, he misused his position as a soldier to organize this dissent and these peace activities within an Army unit. And while he has a right as a private soldier or as a private citizen to sign any petition, when he publicizes his rank and position, it is a misuse and distortion of that right.
Mr. Cohn?
Now, there was a lot of testimony, Your Honor, on the question of whether these men were transferred out in the ordinary course of business. The most damaging evidence to the government on this question is the very language in the letter of General Higgins to General Seaman. It says, we should move some other people out along with these dissidents, because that way it will appear as if we did it in the normal course of business. Now, that certainly calls into question the whole line of reasoning that this was done in the normal course of business.
Now, in Cortright's case, you haven't the slightest question on this issue. You have the Chief of Staff saying that flatly that he decided to get rid of Cortright. And so the real question with respect to Cortright is whether there is justification. The Army's position is that they are justified. Your position is that they are not. This is a difficult question.
The gravamen of the case, then, is whether the Army can discharge or transfer people to chill their First Amendment rights or the First Amendment rights of others. If Your Honor upholds this transfer, then the Army will have accomplished what it set out to do. That is, to put fear into people that in exercising their First Amendment rights, they are subject to being sent to all kinds of places.
We can always bring them back if necessary.
Like a retraction in the newspaper, Your Honor, that is not helpful when the newspaper slanders you in the first place and then retracts it. Nobody sees the retraction. If these people are sent over, transferred out, nobody will ever hear that they came back.
Thank you, counsel. I will reserve decision.
Judge Winstein issued a written decision in March 1971. It held as follows.
Discipline, otherwise appropriate and lawful, becomes illegal when it is utilized to suppress First Amendment rights. This court has the power to protect the constitutional rights of members of the armed forces. It is true that courts have traditionally been reluctant to review administrative actions affecting members of the armed forces. However, there is no broad barrier to judicial review in military matters. In the case before us, there are allegations and proof that the Army has acted through transfer and changes in duty assignments to punish the plaintiff and others for the exercise of First Amendment rights. Under the circumstances, this court must take jurisdiction to review the merits of those claims.
Judge Winstein considered Orloff versus Willoughby, a 1953 case in which the Supreme Court observed that, quote, judges are not given the task of running the Army, end quote. Judge Winstein reasoned that Orloff did not bar judicial review of military matters. He then held,
the only instance where significant non-verbal conduct was involved was the off-post demonstration of 5 women on July 4th, 1970. Neither the Article 138 proceeding nor the trial revealed that they were acting other than on their own behalf. Nor was there any evidence that anyone in the band acknowledged their presence or participated in any way in their activity. Holding men responsible for the activities of wives or of sweethearts without proof of any other connection is hardly consonant with due process. Plaintiff's activities created no imminent threat to an interest of the Army that could possibly outweigh the interest in freedom of speech.
Based on this reasoning, Judge Winstein rescinded Cortright's transfer and ordered the Army to return him to Fort Wadsworth.
all rise. The Army appealed Judge Winstein's ruling to the Second Circuit. The appeal was assigned to Judge Henry J. Friendly, Paul R. Hayes, and Judge L. Oakes. The panel heard oral argument in June 1971. Anthony Steinmeier from the Department of Justice argued for the Army. Reg Cohen again represented Cortright. No transcript of the argument exists, but we have reconstructed the argument based on the briefs and the court's decision. You may all be seated.
May it please the court, Anthony Steinmeier for the Army. Specialist David Cortright was the leader of an anti-war faction within his unit, the 26th Army Band. His commanding officer, General Chico Lela, determined that Cortright protest activities weakened the morale, discipline, and effectiveness of the unit, and that the band could no longer perform its public relations mission or its mission to be ready to fight for this country. General Chico Lela therefore reasonably and appropriately ordered Cortright's transfer to another unit. In fact, it was General Chico Lela's duty to do so. We submit that Judge Winstein erred in determining that Cortright's transfer violated his First Amendment rights.
Mr. Steinmeier, doesn't the First Amendment afford all citizens, including servicemen, the right to voice some beliefs that some find disagreeable, beliefs that may even cause dissension?
Judge Oakes, it is not the government's position that the servicemen forfeit all their constitutional rights. But the law recognizes that the need for military discipline justifies limitations on a soldier's freedom of expression that would not be acceptable in the civilian context. When soldiers are representing the United States Army, when they are leading a parade on the 4th of July, during a time of war, they may not exercise their right to free speech, as Cortright and other band members did here.
Counselor, did Cortright's activities in fact encourage dissension?
Well, one of the concerns here is that anti-war activities, such as Cortright's, can reduce a military unit's readiness to fight. Although the district court found only a remote possibility that band members would be called to combat, in fact, at least 2 band members have been ordered to Vietnam.
But what specifically did Cortright do? The district court found that Cortright had made no role in his wife's participation in the July 4th parade. Aren't we bound by that finding of fact?
Judge Oaks, the government's position is that the district court's finding was clearly erroneous. The record shows unequivocally that when Cortright learned that some of the wives were planning to demonstrate at the parade, he told his fiancée to contact them. Cortright was directly involved.
To what extent do we, that is the federal courts, have power to review discretionary orders of the military?
Respectfully, Your Honor, none. The Army's discretion to decide where Mr. Cortright should serve or where the members of the 26th Army Band can best carry out their duties is not subject to judicial review. Both the Supreme Court and this court have held that military authorities are accountable only to the President and to Congress for decisions of the type at issue here. Orloff v. Willoughby forecloses judicial inquiry into military orders. To hold otherwise would create great disruption for the armed forces and risk a flood of unmeritorious applications challenging military orders. For this reason as well, the district court's order should be reversed.
Thank you, Mr. Steinmeier. We'll hear now from Mr. Cohen on behalf of Mr. Cortright.
May it please the court. Your Honors, David Cortright and the other members of the band performed with distinction and as a credit to the Army. The question here is,
does this court have authority to review Cortright's transfer order at all? Didn't the Supreme Court suggest in Orloff that courts have no authority to revise duty orders as to one lawfully in the armed services?
Judge Friendly, Orloff and the other cases cited by the Army on non-reviewability are not on point. None deals with the basic constitutional issue of whether a serviceman's First Amendment rights provide real, tangible protections, or whether they simply collapse under the weight of a military uniform. This is a basic constitutional issue that was not addressed in the Article 138 proceeding, and is one that only a constitutional court can resolve.
How do you respond to the Army's assertion that Mr. Cortright, through his anti-war activities, has impaired the country's military preparedness?
Mr. Cortright's actions have not impaired this country's military preparedness in any way, and there's no evidence that suggests otherwise. Apart from generalized concerns about morale, the Army has not identified any harm resulting from Cortright's actions. The band members never disobeyed an order, and they always performed admirably. It is simply not in the Army's interest to prevent the sort of disharmony that results from the mere expression of controversial ideas.
What about Cortright's purported activities in the July 4th parade?
The military command made much of the women's demonstration at the parade. General Ciccalella testified that in the military, we hold the husbands somewhat accountable for the actions of their wives. Needless to say, in the 1970s, even in the Army, that is a most chauvinistic attitude. Indeed, the entire record demonstrates that on that occasion, the men behaved with great discipline in refusing to come to the aid of their loved ones during a tense situation. Certainly, it cannot be the action of a wife that makes one subject to the punitive use of administrative power.
Thank you, Mr. Cohen. The court reserves decision.
While Judge Weinstein was able to reach a decision on his own, the three appellate judges had to decide as a panel, and they engaged in deliberation by circulating voting memos to each other.
Judges Hayes and Friendly voted to reverse, while Judge Oaks voted to affirm. Here are excerpts from their memos.
I vote to reverse and to dismiss the complaint. Federal courts have only a limited power to review discretionary actions of the armed forces with respect to assignment of personnel who have been legally inducted. Cortright's transfer to a new post is a subject on which civil review of discretionary authority action by the military should be declined.
Tentatively, I vote to reverse. This is a tough case involving a tension between the undesirability of the civilian courts interfering with the internal operations of the Army and the need for protecting First Amendment rights of military personnel. The one thing about which we can be certain is that we will be panned, however we decide. I would wait for a stronger case of interference before taking the plunge. The Army's reactions may have had, and probably did have, a tendency to chill further assertions of First Amendment rights. I believe we have to accept some chilling as the price of avoiding disruption of the Army.
A war, unpopular with most everyone, including soldiers, presents the courts with a complicated new problem. Perhaps the most difficult problem is the extent to which military transfer orders may be interfered with by the courts. Orloff says that the judiciary must be, quote, scrupulous not to interfere with legitimate Army matters, end quote. The legitimate exercise of First Amendment rights is, however, not exclusively an Army matter, even though the exercise is by one of military service. Judge Winstein's opinion below is particularly persuasive to me in that regard. Even a very little chill on a very big right is too much. I vote to affirm with not inconsiderable hesitancy, however.
The judge's tentative votes did not change after further consideration. Judge Friendly circulated a draft majority opinion reversing, and Judge Oaks circulated a dissent. On August 16, 1971, Judge Friendly sent another memo, handwritten from Germany.
JLO's dissent does not dispose me to make any change in the majority opinion. We are not in disagreement on the basic principles. JLO thinks Weinstein made findings by which we are bound. I think rather that we have paid attention to evidence which he simply brushed aside. We should dispose of this case before a question of mootness arises when Cortright is discharged, as I think he shortly will be. Accordingly, I would like the opinion to be filed as soon as possible.
The panel filed majority and dissenting opinions just 3 days later. The majority held that the district court had jurisdiction to hear the case, but that the Army had not violated Cortright's free speech rights.
If Cortright and his like-minded friends had limited themselves to signing peace petitions or engaging in protest marches while on leave, the Army command would not have interfered in any way. What triggered the difficulties here was the prearranged participation of Cortright's fiancée and the 4 wives in the July 4 parade. While these ladies had every right to engage in a protest march of their own and carry such signs as they wished, it does not follow that band members were entitled to arrange for their accompanying the band when it was performing its mission of leading a 4th of July parade. It is true enough that a private citizen may not constitutionally be convicted under a general breach of peace statute for making a speech simply because this has stirred people to anger, invited public dispute, or brought about a condition of unrest. But this is precisely the area where a soldier, when wearing his uniform and performing a military assignment with his unit, may be subjected to discipline for contributing to disorder to which a civilian could not. Judicial interference with transfer orders valid on their face must await a stronger showing than Cortright's. The order is reversed with instructions to dismiss the complaint.
Judge Oaks began his dissent with the opening line from his voting memo.
A war, unpopular with many, including soldiers, presents the court with complicated problems. The majority opinion relies almost exclusively on the July 4th incident involving 4 wives of band members and Cortright's fiancée to justify the interference with freedom of expression here. The majority condemns Cortright for sanctioning and arranging for the women to accompany the band on the July 4th parade. Judge Winstein, however, found that the women were acting on their own behalf. I believe we are bound by this finding. the majority would await a stronger case to intervene to protect servicemen's First Amendment rights. I suspect there would be those who counseled waiting for a higher tax before throwing the tea into the Boston Harbor, or suggested Andrew Hamilton that he waited for a client with a better case than the John Peter Zenger to argue for free expression.
The Supreme Court denied certiorari in 1972 and the case came to an end. The Vietnam War continued for 3 more years. By the time the war ended with the fall of Saigon in 1975, some 3 million people had been killed, including 58,000 Americans.
Fred Cohen and Martin Stola were members of a group in Manhattan called the Law Collective, and they represented Cortright and his colleagues pro bono. At one point, members of the band, many of them who were top musicians, performed a concert at a New York club to raise funds to help cover costs. Both Cohen and Stoller went on to distinguished careers as criminal defense lawyers. Cohen, a mainstay of the Capital Defense Panel, became known for his Fu Manchu mustache and acid wit in the courtroom. Stoller continued his representation of dissident clients, representing Occupy Wall Street protesters and veterans arrested for protesting U.S. military involvement in Afghanistan.
Judge Winstein was a relatively young judge when he heard the Cortright case. He had been appointed only 3 years earlier. He was intimately familiar with the challenges of military command, as he had served during World War II as a lieutenant in the U.S. Navy, including as a desk officer on a submarine. He went on to become one of the great trial judges of our time.
And as for David Cortright, he served the rest of his enlistment at Fort Bliss in Texas, eventually playing in the Army band there. He continued his anti-war efforts while in the Army, distributing anti-war literature and helping organize peace demonstrations involving soldiers. Eventually, Cortright went on to become a scholar and peace activist, publishing extensively on the topic of nonviolent social change and teaching at the University of Notre Dame's Institute of International Peace Studies.
Professor Cortright has taught students from all over the world, and together with his wife, Karen, has traveled far from South Bend to further the mission of the Institute. Recently, Cortright reflected on his wartime actions as follows.
Our purpose was to draw attention to the soldiers and veterans who were speaking out against the war, to increase the visibility of resistance and dissent inside the military. We felt a responsibility to speak out, that it was our patriotic duty to warn the nation against what we believed was an unjust, immoral war, a war that was destroying our country, that was tearing apart the military from inside. We believed that if people could see that soldiers and veterans, those most directly involved, those closest to the war, were speaking out against the war and the killing, that perhaps people would feel empowered and would themselves have the courage to speak out against the war, and that finally we could bring this abominable war to an end. Thank you. We have time now for questions, but I wanted to make sure that we thank all those who helped, Dean Newton and Associate Dean Kozel here at the law school, to Asher Kaufman, Aaron Cochran, and so many others at the Kroc Institute who made this possible as well. And especially to our Kroc staff, our program staff who now have a budding career in stage direction, Laura Stone and Kate Paulson.
Any questions?
Thank you very much. I have a very simple question, and I assume I'm probably not the only one who's wondering about this, but looking back now, all these years later, does it matter who won and lost the case in the end? What is the significance of losing the appeal today?
Let me talk about the political side. You can talk about the legal aspects. And yeah, for us as soldiers, we really didn't know much about the law. We were just trying to fight back against this punishment that we were experiencing. And as I mentioned, we were trying to spread the word about soldiers speaking out. in social action, nonviolent social change, one uses the law from time to time. Sometimes you win, sometimes you lose, but the point is to be fighting back and to always be trying to draw attention to your case and trying to show a positive voice that people can support.
Yeah, I think one of the practical results, and Professor Cortright explained this to us in Hawaii, was that they were waiting for him in Texas. There was a strong anti-war movement among the servicemen in Fort Bliss, and they were delighted to have him there, and maybe he got to accomplish more being with this group in Texas. In terms of the law, you know, I don't know that this is one of the most significant cases in history, in part because it's a relatively narrow area. Soldiers protesting war. I think one of the things you could see from the internal deliberations is that it was a difficult case. It was a close case. You had a very respected judge, Judge Oaks, dissenting. You had Judge Winstein in the trial court ruling in Professor Cortright's favor. So if you look at the four judges, it was 2-2. You know, it's hard to draw too much from that. But I think a lot of what we do as judges is balance, and you're trying to balance the First Amendment rights of soldiers against the articulated reason of trying to maintain good discipline, military order. Myself, I do disagree with the suggestion that they should be held responsible for the actions of their wives. But remember, this is 40 years ago. I think times were different. So the thinking was a little bit different. Also, you know, as an appellate judge, you want to give deference to the trial judge's findings. And the trial judge found that there really was no meaningful involvement. And so I think that's something that should have, that deserves some greater deference. Other questions? This is your chance to ask questions of us.
I noticed one of the lawyers on, I believe it was the defense side in the original case, argued that I believe the circuit has previously, or someone had previously declared that servicemen have no constitutional rights or something. It was a very broad statement. I was wondering, was that accurate? What was that based on? Or was it sort of hyperbole on the part of that arguing attorney?
Well, it won't shock you that lawyers sometimes will exaggerate, even in court. I'm not sure if there's a Second Circuit case that's precisely on point. I suspect that if the answer were yes, that would have been front and center in the judge's rulings, and it wasn't. If there was a Second Circuit case on point, Judge Oaks would have been bound, and he would not have been even to dissent. He could have written a concurrence saying, you know, I'm bound by this prior case, even though I disagree. So I think the answer is there wasn't a binding, controlling Second Circuit case. But I actually thought the same thing as we were going through it again. Did I miss something? Was there a case out there? But I think the answer is no, because it would have been in the opinions.
I was hoping you could speak to the chilling effect of the case, and what it was like immediately following the holding, the servicemen in Texas, and how do you think that's changed or remained the same until today?
Yeah, thank you. Well, there was definitely a chilling effect. I mean, the script goes through the discussion about the second petition. When they made these threats, it didn't change our opinions about the war, but it certainly made it clear to us that the command was going to punish us if we kept going without protest. And as you heard, a number of the soldiers withdrew their names. It was an agonizing debate for us, a difficult one. We all felt this obligation to speak out, but we also didn't want to have everybody in the whole unit punished because of the actions of the command. So definitely this has a chilling effect. And it took a kind of an extra degree, I don't know if it was courage or craziness, but we weren't going to be silenced. Some of us felt determined to keep speaking out, and then we filed a lawsuit. But there were many soldiers who spoke out all across the Army, and everyone who spoke out as vocally as I did faced some kind of punishment. Usually it was much more severe than what I faced. And other soldiers could see this, and it was intended to keep the other soldiers quiet, and it did have that effect.
Yeah, you know, we've had a number of discussions now, but the times were different. There was no email, there was no Twitter. Some of the GIs in different places were mimeographing newsletters. I think there were a couple of them in the slides, and that's how they were trying to spread the word. You couldn't do an email blast. So it's a different era, a different time. Another important fact is that the draft was still in place. A lot of folks were being drafted. They didn't want to be in the war, but they had no choice. So this was all part of the dynamic back then too.
I mean, we were fortunate, we were based in New York, and so those lawyers available to help at the press center. Most of the soldiers are in these rural bases far away from cities, where it's easier for the military to crush dissent if they want.
Yeah, apparently Mr. Cohen's nickname was Red. He was one of a number of lawyers in New York who were very progressive and took on radical causes, Lynn Stewart, others, and he was one of them. He went, after things calmed down, he wound up doing just ordinary criminal cases, drug cases. I had him on trial in front of me, and he was definitely a colorful character.
So I'm wondering, I'm taking a follow-up from your notion that we're in a different time. And I'm wondering if you all would speculate today, where there have been experiences even of soldiers internally being radicalized against the Army and in this time of terror. Would you argue the case the same way, or do you think that dissent has the same freedom, or should we reconsider how we thought about it 40 years ago?
Yeah, I think, the times are different. I think there is, it's hard to say, I was fairly young back then, but it seems to me there's a greater emphasis on First Amendment rights and on constitutional rights today. Maybe there would be more tolerance for dissent today, I'm guessing. Maybe that's wishful thinking. And so perhaps, you could also see the notions of the male-female relationship, husband-wife relationship affecting the decision-making. Judges in general tend to be conservative. Judge Winstein once wrote a famous opinion about how judges really don't know about discrimination and sexual harassment because they come from a certain part of society. Another example would be technology and social media. In the Second Circuit, we still fax our opinions to each other, and none of us are on Facebook. And so if you're a lawyer and you're in the Supreme Court arguing a copyright case that involves technology, when I had one of my cases go to the Supreme Court, and the analogy was to a phonograph player and to parking garages, to try and use analogies that these Supreme Court justices could relate to. So you do have to adjust your thinking and your arguments.
And there have been some cases of soldiers speaking out against the Iraq War in particular. Even though we're in an era of the volunteer army, they don't have folks like me, reluctant volunteers, very reluctant. But soldiers, I think, have gone through, some of them, a similar kind of crisis of conscience or a broader understanding once they were in to see what was happening in Iraq. There was a winter soldier hearing in 2008 in which 50 of the Iraq veterans and Afghanistan veterans talked about what they had experienced. There was even a mass petition that was organized by Petty Officer Jonathan Hutto in the Navy. But since petitions have now been outlawed, they kind of disguised it as a petition or an appeal to members of Congress through the Whistleblowers Act. And so you just happen to have about 2,000 active duty members submitting a whistleblower appeal at the same time, petition by another name. So they had to be more clever and and they were kind of barracks lawyers. and looked at the regs to figure out what they could do and not fall on the wrong side of the law.
Yeah, and the dean and I were discussing earlier, another difference is the draft makes a big difference. The armed services today probably are poorer, probably less educated. Back then, a lot of the guys who were being drafted were college graduates. When we did the program in Hawaii, someone talked about how he signed up for JAG so that he didn't have to go to Vietnam. There were other options. These were talented musicians who were in this group. They were Juilliard-trained musicians, but there they were. But again, that dynamic, I think, is also different.
David, lawyers and law students have a confidence in the courtrooms, though we never fully get over our fear of the black robe. We're trained, we're prepared to operate in the courtroom. It's a fully different experience when you are sitting in the witness stand or when you are the victim of a rights violation. Can you talk about what it was like for you to sit on that witness stand?
Well, I really wasn't fearful because for me, I was seeing the court as our defense. We were fighting against the punishments. And afterwards, there was a press gathering, and they asked us questions. And the first question was, how did you first get in trouble with the Army? I said, well, we're not in trouble with the Army. The Army's in trouble with us. They're suppressing our First Amendment rights. And so I think I did feel that sense. I didn't feel over intimidated or fearful, and was really trying to plead our case. And glad to have an attorney to help us.
And how did you feel after the Second Circuit ruled against you?
Oh, it was a bummer. It was right about the time I was getting out of the Army. And I had actually, in those days, because the Army was really falling apart, they offered early outs to almost everybody. You just had to sign up and you could get out 3 or 6 months early. And I wanted to do that, but the attorney said, well, then the case will be moved, so stay in. That was depressing. And then I stayed in while we lost the court case, so that was double depressing.
Why didn't you go to the Supremes?
I believe the question was, why did it go to the Supreme Court? I don't know. Did you seek cert?
It was, but it was denied review. The certiorari was denied. It was 8-1. William O. Douglas was sorry.
So a few of us at Kroc have law degrees, but most of us don't. And I wonder if you can speak about this trial as a teaching tool in law classes.
About the reenactments as a teaching?
No, the actual trial.
Oh, the actual trial.
As a teaching tool for law students. What do you do? How do you use such a trial as a teaching tool in class?
Yeah, most of the time it's the appellate decisions that are taught in law school because law school is more interested in the law. And I do think it would be great if more attention was paid to the trials. It's hard to find these transcripts. And then what do you do with, I don't remember how many pages there are for your trial, several hundred pages of transcripts. Law students can only absorb so much. I don't know, but for me, part of the fun of doing these things is the stories of the people, and you learn a lot from storytelling. Storytelling is a really important skill for a good trial lawyer, and how to summarize it in a way that gets the essence of the case, in a way that makes it sympathetic. So I do think more attention ought to be paid to what happens at the trial court. But when you read the case books in law school, it's mainly the appellate decisions that are taught and read.
And we're very grateful to you and Kathy for doing these reenactments. It's a wonderful way to encapsulate this long, difficult, complex argument into 55 minutes like this. It's a great job.
The fiance's prerogative and the wife's prerogative. Knowing David for so long,
there was repercussions. You had a military intelligence file once the Freedom of Information Act was enacted, that you were able to get your military intelligence file. And for some of you that don't know, David was the drum major of the Notre Dame marching band when he graduated, and he, O'Brien was the director of marching band, a historic figure here at Notre Dame. And when the FBI or the military intelligence came to his office, I'll let you tell the rest of the story.
Yeah, so that part of what the Army Intelligence did was do interviews with all my teachers and priests back home, and family members, and one of them was Mr. O'Brien. And so they came in, and we know that you were corresponding with Cortright, and we want those records. I said, you're not getting them. Because he hated Nixon. So then I said, well, we can come back with a subpoena. He said, well, then I'll have all the records burned when you come back. Yeah, maybe one more question.
Another non-lawyer question. I was very struck by Mr. Cohn's argument that when he cited the letter, there seemed to be a smoking gun. You're going to transfer him and others, so it won't be appears before dissent. Do we have any record of discussion among the appellate judges about that point?
And by the way, it's rare to even know what the judges were thinking. These voting memos, which we still do today, go back and forth. They are usually not made public. But Judge Hayes, his family gave some of the voting memos to a professor, a writer, and then some of the others surfaced. And so those are the actual copies, and someone took cell phone photographs of them. So it's very unusual to know what the judges were thinking. The memos were actually quite short, and I don't believe there was any discussion about the smoking gun letter. But there's a funny story about the letter. Maybe you should tell about the carbon paper thing.
Yeah.
Ribbon, the typewriter.
Yeah, ribbon. Yeah. I was in Fort Bliss, but the fellow band members and my wives were still organizing at Fort Hamilton, and with Fred Cohn's advice, he said, can you find any records of what was going on? And in the Army, everything depends on the company clerk. Those of you who read the book Catch-22, remember the moral character ex-TFC Wintergreen, who controlled everything, was the most powerful person in the military. Well, we had our ex-TFC Wintergreen, and he said, I remember typing a letter for the general to one of the other generals in which they called Cortright a troublemaker, and they had to deal with him. And he said, well, that would be great. So they went through their old electric typewriter ribbons, and they had a pizza party one night with lots of pizza and beer. Eventually they found it, and they recreated a letter from the general, and they showed it to Attorney Cohn. He says, that's very clever, but this is not admissible evidence in court. But he said, well, type it out. Reproduce it on Fort Hamilton Stationery, and we'll see what we can do with it. And, he was waving it around in front of the general on the stand, and without having to use it, he kind of got the letter into the discussion. Again, well, thanks especially to our